and we'll try to answer the question if you have to comply with this regulation. For example, if you run your company in Chinese, but you have business partner or clients in EU. So what's the plan? First of all, we'll talk about the GDPR itself, so General Data Protection Act in Europe and in the whole world, and we'll try to figure out, does it apply to you? Then we'll talk about definition of a personal data. Because it's still a little bit problematic. It's a very broad term, and actually it's become broader and broader each year. We'll talk about the mystical figure of data protection officer and the representative in the EU. Two key figures if you have your business in the European Union and you have to deal with the data protection. Then we'll also present the main responsibilities of the data controller. So what documentation we need, what is the retention issue, and of course, my favorite, privacy by design. So combining the privacy with the business projects. So GDPR and business, but also next point will be GDPR and marketing. Quite important if we want to have more and more clients. And on the end, we'll also present the legal liability and maybe not most interesting, but the biggest fines yet. And so, what are the origins of the GDPR? It's quite interesting because, as you can see on the right, we have GDPR since 2016. Before, we also have in European Union the EU directive, and as you maybe know, the EU directive has to be implemented in each and every European country. So you have the rules, and then you have to put it in paper in a legal act in each and every country. So the effect was there were a little bit or quite significant differences between, for example, data protection in Germany, the data protection in England, or data protection in Holland. And it was, of course, problematic mostly for business. If you have a group of companies and you have your IT system, you have to make changes according to a local law. So it was bad for business. Also, this previous law was created in 1995. As you know, that this was the year of the Steven Spielberg Jurassic Park. So it was also breakthrough in a technology, in the internet, and the old law was completely not up to date to this nowadays standard. So the reasons for the change was, among others, technological development, globalization of personal data flows. Now we exchange data in a microseconds, gigabytes of data flow through China to Europe to Australia. Nobody's seen it back then in 1995. So they wanted to adapt the law, the EU law, to the new technologies and also make it flexible. So the Parliament and Commission wanted to prepare an act that will go through decades, maybe not centuries, but decades, without a need to change. So make it flexible, put down the rules that can apply to any technology. So the technical neutrality is one of the main factors here. Also, of course, the harmonization of personal data standards in the whole EU. And now, from 2018, because the GDPR was prepared in 2016, but came into power in 2018, we have one EU law that is directly applicable in all member states. So you have GDPR in the same form in France, Germany, Poland, Hungary, etc. In all European countries, we have one legal act, which is quite convenient if we want to do business with all of them, or only with some. So what is the territorial scope of the GDPR? You can see on the slide that there are two rules. First of all, if we have a company, the first point is directly copied from the old law. So if we have a company in Europe and we process the data, it does not matter where we do it. So for example, I have a company in France, but I have my servers in China, in Australia, on the moon. It does not matter. If I have a business in European Union and I process the data and this processing is strictly connected to my business activity, I have to comply with GDPR. That was the rule before, that's now, nothing has changed. But, and here there is a most important thing. Here we have the element of even that if we have a business outside the company, outside the EU, for example, in China, and we offer goods or services to people in European Union, which data we process. So for example, we have some shop in China and we have a client from Europe, but the key factor here is that our business have to be pointed on this sector. So for example, we have Chinese clients and among them 2 European guys. Nobody know why, but they bought something. This is not the case. GDPR does not apply. But when we have a company that wants to have clients, that targets clients from the European Union, offer goods, services, etc., we have to comply with the GDPR. So on the left, you can see we have a data flow, data of a person, people from European Union. We offer goods or services. And the third case, we monitor of their behavior. Of course, if this behavior takes place within the union. And it sounds strangely, but in fact, this consider most online applications. Everything that goes with online portals, with the application we carry out in our mobile phones. So then if we have this apps, when we offer these apps to EU customers, then we monitor their behavior. So we have to comply with the GDPR. As you can see, and this is interesting fact, that the territorial scope of the GDPR is the biggest of all EU acts. There is no EU acts, no EU law that have such a large scope, the territorial scope. So remember, data of people from EU, goods or services, or monitoring of their behavior, so all the online apps, etc. Okay, but we talk about GDPR, we talk about personal data protection, so what actually are this personal data? On the left or on the right, depends which language version you prefer, you have the definition. The definition is simple but still problematic, and actually made of the 2 parts, because as you can read, personal data means any information relating to an identified or identifiable natural person. So to make it simple or simpler, this definition is actually made of 2. First of all, we can break this sentence into 2. Personal data means any information relating to an identified person. So if we have a person that we can easily identify, for example, our employee, we have an employee in a company. So each and every information about him we process is considered his personal data. So if we have his name, surname, email address, local address, but also his preference, that he likes Chinese food, that he likes European movies and American blockbusters. This is all personal data. There is no legal or factual boundaries that says, okay, this information is so small, so irrelevant that we should not consider it personal data. So this definition is very broad and can be quite problematic, because if those are personal data, we have to have control over it. As you can see on the right, you have examples. So passport ID, but also IP address, even if it's changing, it's dynamic. The European Court of Justice decided that IP addresses is also considered a personal data. Also, cookie files. There was quite a discussion if the cookie files are or are not personal data. Some time ago, there was also a decision of European Court of Justice who stopped this discussion quite abruptly and said, well, it does not matter. You have to treat it as personal data. So now we know. But this is only a first half of the definition. So any information relating to an identified person, first part, and then identifiable natural person. So the person we can identify using some information. We do not have, for example, his name and surname, but we have GPS. We can see how the person moves, or we have the cookies, so we can monitor the behavior in the internet. But also, if we can have some basic information, I will give you an example. There was a very handsome blonde husband of Angelina Jolie actress. Yeah, so we can put the puzzles together and said, okay, this was Brad Pitt, personal data. Or if I will set the chairman of the board of the Microsoft was who? Most famous, I said, Bill Gates. So we have some parts, and if it's easy to put them together, not being Sherlock Holmes, and discover who is the person, then once more we have personal data. And the key thing is that GDPR changed our approach to data, because before we were talking about databases. For example, we have marketing databases, we have employees databases, we have client databases. GDPR changed it. Now we have to think more of the data flows, how the data flows in our company. For example, if we have employee, his data runs through multiple processes in our organization. Yeah, we have recruitment process, we have payroll, we have his business activities, we have his training, we have his evaluation. So same basic data are then used and enriched through different processes in organization. So that's how our approach should change. We have new definitions.
Michał, sorry for interruption, but we should add something about entrepreneurs, because Data Protection Act is applying to entrepreneurs. It's very, very important thing, because a lot of people think that if you are an entrepreneur, that means you're not a personal, a physical person, but we apply to entrepreneurs, and this is very, very important thing.
Yeah, true. This is quite a challenge, because before the old law was could not be applied to the, for example, people running their business, like, for example, Michael Czarnecki, legal advisors. We won't use the GDPR, but now it has changed. So of course, the companies like, I don't know, Microsoft, Amazon, they are not treated as a personal data because they are names of a company. But if you have a clients that are this one-person interpreters, like, for example, I don't know, Lukas Sosnowski, advisory, Helen Tang, communication consultancy, then we have to also treat this as a personal data, which is quite complicated, as you can imagine, because when you have to manage the lists of your client, the Excel tables, the reports, you have to be aware that you have that right now you also process the personal data. And maybe I will add one more definition, because we are talking about processing personal data. And two days ago, one person asked me, but what does processing actually means? Well, there is no closed definition, but there is an open definition, the GDPR, and actually processing of personal data means everything you could do possibly with the data. So if you collect them, if you change them, if you modify, if you send them to other recipients, if you delete them, every operation on a personal data is data processing. And we have some new definitions. I wanted to show them to you also as a proof that the approach has changed and new technology has also entered the GDPR. So we have the biometric data, and we all knew that we also use them in business. So if we have any security measures using fingerprints, eyeball, etc., the GDPR also apply. On the right, you can see profiling. So when we use some also automatic system to analyze, to predict some behaviors, the basic profiling is for marketing. Yeah? We also have to comply with GDPR, and sometimes we have to have a consent. Be aware that Facebook was get a penalty of, I guess, 300 or 400 million euros because of the profiling without a proper consent. So this is something to consider. Then then you can see anonymization and pseudonymization. And I put it there also because GDPR directly states that we should use this two mechanism when needed. So GDPR says if we do not need a data, we should anonymize it. So for example, we have some business reports or lists of clients or employees. We need numbers, but we do not need, for example, name and surnames. So we anonymize the data. So we delete the information that allows us to identify particular people. This is one of the processes that we should use in your organization. And second one is pseudonymization. The difference is the anonymization is one-way ticket. We should not be able to reverse it. Otherwise, it's actually not anonymization. So pseudonymization is actually the mechanism, the rule in which we make some operations, we process the data, but we do not need the basic information that allow us to identify the person. For example, if we have a payroll list of our employees, so who earns how much and when should we send the money, we can have the list like Michael Czarnecki, 10 million euros, let's dream big, a month. Then Lukasz Sosnowski, 8 million, Helenta, 15, Thomas, 11. This is a normal list. So the GDPR says, okay, always when you have to run some processes on a personal data, you have risk. For example, this list might go public and make us some trouble. So what we should do is, when possible, pseudonymize it. So use a pseudonym. For example, Michael Czarnecki will be, I don't know, number 7, Helen, number 8, Lucas, number 9, Thomas, number 13. And then this list will look different, like 7, 10, 8, 15 millions. So we use pseudonymization, some other information instead, and then, of course, we can connect this data and we know that Michael Czarnecki is number 7, so he earns this 10 million euros. Thanks to that, we a little bit minimize the risks. And we know already what's the definition of personal data, the processing, the scope. And now we want to show you the two key figures in this data protection system in our organization. The data protection officer and the representative in European Union. They are two separate individuals, and of course, their tasks differ. So who is data protection officer? This is actually an idea that was firstly introduced in GDPR. And the idea was that sometimes you have to, or you can, well, you always can facultatively, but sometimes you have to have a person that is responsible for advising you in a privacy area in the company. So, for example, here you have two rules, two circumstances when you have to. It's your legal obligation to have this data protection officer. Of course, I will briefly talk about his tasks and position in our organization. But if you, for example, regularly and systematically monitor the data subjects, so on a large scale, so for example, you have this mobile applications, then you have to have this data protection officer in your organization because you have a contact with higher risks, let's say. You may ask, what is a large scale? Which is a funny thing because, of course, large scale will differ. In some of the Chinese laws, for example, where a large on high risk incident is considered to be incident on a scale of 100 million people, which is more than average number of citizens of each European country. So in GDPR, there is no definition of a large scale. It's subjective, but you have to consider, of course, the number of people, the scope of the data, and the territorial scope. So these three issues have to be taken into account when estimating if it's a large scale. So if we monitor the data subjects on a large scale, we have to have a data protection officer in our company. The second one is if our core activities consist processing on a large scale special categories of data. So special categories of data are also, let's say, more sensitive data, considering, for example, religion belief, health data, so all the whole health sector, as you can probably figure out, then sexual orientation, gender, biometric data, etc. So this data that are related to higher risks. So this is data protection officer, a person that should support us in building and maintaining the data protection system in the organization. Then we have EU representative, and who's this person? Well, if, as you remember from the beginning, if you have a company outside the European Union, but you are in these two scenarios, so you offer goods or services to the EU citizens, and you also monitor their activities, then you have to, this is interesting, you have to have this EU representative, so you have to have someone in a European Union who will be a contact person, for example, for supervisory authorities in European Union. And this is also a legal obligation of your company. So two different persons, one supporting the system and one being a contact point for EU institutions. I will also shortly tell you what are the consequences of not appointing the EU representative soon. So this data protection officer, three main issues is his, for example, firstly, his qualification. So he has to have knowledge and experience. It's obvious, but it was also stated directly in GDPR, because this is someone who will support you. This is something, for example, we do daily. We also act as a data protection officer for biggest EU companies, and we help to prepare, maintain, and secure the data flows in organization. What's his status? Actually, this is also interesting and sometimes problematic because he should be independent. He should be independent and subject only to the highest management. So normally he reported directly to the board. And of course, we can have him as or her as employee or a contractor. This does not matter. So there should not be a problem with his independence. So for example, if he would be hired in a legal department and he would have to report to the director of this legal department, we will have the breach of this rule because he have to or she have to be independent. And what are the tasks? The tasks are informing, monitoring, educating, and advising. As you can see, data protection is responsible for supporting, but he's not responsible for the working and the condition of the system. This is a sole responsibility of the company. So the company is always responsible, but the data protection officer support, inform, monitor, and educate her for the system to work well, optimally, I hope. So here you have the details about the tasks of the data protection officer. You have to inform and advise, what we stated before. So monitor compliance with the GDPR, including the assignment of responsibilities, awareness raising, so trainings, and provide audits. And you have to remember that compliance with the GDPR, it's not only compliance with the General Data Protection Act. It's not, because the data protection system considers a lot of legal acts. For example, labor law, civil law, tax law, new technology law. In each of this legislation, we also process the personal data, and that's the challenge. The data protection officer, the DPO, have to, well, know them to the best of his knowledge and be able to monitor the compliance of the company activities with those legislations. So he provides advice and also he helps to assess the risks to the organizations, because GDPR also changed this approach from formally to risk-based approach. So now we do not only look on the documents. The documents are only part of the data protection system, part of our accountability. So part of following the rules and be able to show that we follow the rules. But also we have to assess the risk. So for example, if we, let's say, want to create a new application, we have to be able to assess what are the risks, but not for the company. Not to the company, but to the data subject. Now you can see what the key factor is. It's switched our attention from interest of the company, well, for a second, to the interest of the data subject. So for example, we have this application and we want to support, for example, some medical procedures. Let's say the sugar, amount of sugar in the blood. So we have to assess what data of what people we gather, how we do it, what are the risks for a person, for example, that the data will be deleted, make public. What if our application would mislead a person and make treatment ineffective? So all these factors we have to also take in account, because the consequences are results from the processing of the data we collect. DPO is also a person that cooperates with the supervisory authority. So GDPR stated that in each and every country, you have this data protection office, let's say. The name, of course, differs. Data protection protector, etc. So the supervisory authority that is, of course, monitoring the private and public sector. So the DPO acts as a point of contact for the supervisory authority, and also it's a point of contact for people. So if our employees, our clients want to ask and make some requests considering data protection, then they can always contact DPO. And one thing that I will add here, as I mentioned, sometimes we have to appoint the DPO. Before we had this two situation when we monitor and when we have this large amount of special categories of data, but we can always do it on our free will. So we can always say, well, you know, our business, in our business, we have a lot of personal data. We would need such a person. It would be a good idea to have a person that will support us in this area. And being honest, in EU, when you evaluate your future partner, the company you will cooperate, normally you will have this GDPR survey. So you will have questions from your future possible business partner. Do you comply with the GDPR? Have you appointed data protection officer? Have you trained your staff? Do you have all the procedures and audits done? So actually it's become more and more a business requirement, although it's still optional.
Michał, Michael, sorry for interruption, but I don't want to interrupt you every time, but I think some things are very important. I wanted to say about this not obligatory, because sometimes we appoint DPO and sometimes not. But what is important, if we have any doubts that it's obligatory or not, sometimes it's better to apply, because it's very, very good in business relationships. That what you said before, that someone ask and send us a list and ask for compliance, GDPR compliance. The first question is very often do you apply at DPO? And if you have, that means you are professional, and it's better. It's a partner to discussion. This is very important, that you have someone who knows, and it's responsible, because the role of the DPO it's very complicated. We have said it's a tough role, because it's between a person and between your boss, that someone employs you, and someone who will check or investigate. It's your role. But in business, so if you have doubts, it's the same like in definition of data. If you have doubts, it's better to say yes and to apply.
Mm-hmm. Yeah, and of course, very often when we make some big deals, for example, last year, or it was maybe 2 years ago, because time flies, we have to conclude the deal with one of the biggest Chinese online selling platform. And one of the main issues was also the data flow, the data protection agreement, and of course, our DPO, our data protection officer in Poland, was involved. I would not say the name of the company. So what are the consequences if you want appointed? Actually, they are quite severe, because not appointing a DPO or not appointing an EU representative can be punished, and as you can see, up to 10 million euros, or 2% of a total worldwide annual turnover. So you can see that in 2022, the Greek authority, this local supervisory authority, have imposed a fine on this Clearview IE company, 20 million euros. As you can see, it's more than 10 because the supervisory authority can use this 2% of a total worldwide turnover. So, for example, in terms of the percentage, in case of, I guess, Amazon or GDPR, we are talking about billions of euros. Only as a 2% or 4% of total worldwide turnover. So we are talking about a lot of money. And we have also information obligations, which is quite important. This is one of the most important factor when we are building and we are collecting. We are building a database or we are collecting data, because if we collect the data directly from a person or indirectly, for example, we are using some public database, we always, according to GDPR, have to inform this person, listen, we have just collected your data for this and this reason, because we have, this is our, for example, business goal. So if we have this forms on our website, if we have this online apps in the cell phones, in tablets, if we have a paper forms, we always have to inform the person why, for what purpose we collect the data, and who are we. So what's the name and address of our company? It might be a little bit problematic sometimes, but for example, a few years ago, we were working on this artificial intelligence system that was scrapping, that was automatically sucking the data from the website, the profiles of the particular group of people. And we knew that we have to provide this information obligation. So the artificial intelligence was only collecting the data of the people that it found the contact of. So in the same second when we found the right person, we also were searching for an email or phone number, and in the same second we were sending the information obligations. This is an example actually how you could combine the business with GDPR. And of course the privacy notice. The privacy notice is this magical document that all applications, Amazon, AliExpress, Temu, Microsoft, Facebook, they all have to have. So this is a description of goals, of the details, how and for what we process your personal data. And this is the transparency rules. So the processing of the data should also always be transparent for a data subject, for our clients, for our employees, etc. And you can see already, I think, from the examples that I showed you, that personal data protection, this GDPR, I think, has become also a business requirement. And the thing that is this very important for a prestige of the organization. If you have a good business, but you have very poor culture of processing of data, it will be shown soon, and someone will send information to the supervisory authority soon enough. Then my favorite topic, privacy by design. Privacy by design is also a mechanism described in GDPR, and it's not optional. I will repeat, it's not optional. If you have to comply with GDPR, then you have to implement this mechanism. And this mechanism is actually, I call it GDPR scan. So as you can read, on the beginning of the process, on the beginning of the project, you have to scan this project. if I design a new application, if I am designing a new online shop, I have to scan what type of data I collect, what are the goals, what is the scope of this data, what are the risks, how should I secure this data flows. That have to be done on the beginning, and this is a legal obligation of the company. Legal obligation of company. Failure to do this, breach of this rule can be fined the same way, so up to 10 million euros or 2% of worldly turnover. And actually, when you have to do this, you have to do it on the beginning, but also if you changed drastically, importantly, the project. So for example, I have this online shop, but I will change the website, I will change the servers, then I have to return to my privacy scan, and I have to see, okay, what have changed? Do I have new risks? And do I have to implement a new security measures? And here you can read about the whole idea, so that data protection should be taken into account at every stage of a development of the project. So on the beginning, start, and on the end. So what are actually happening to the personal data? So here you can easily see how GDPR forced us. It forced us to merge the personal data system with the business activities. We are obliged to take this into account in our activities. And also, as a third point, you can see this is an example. So, for example, mobile application of data processing system should be by default provide a minimum amount of information. So, for example, if we have a mobile platform, let's see some I don't know, romantic goals, people to find their love of their life, etc. When we have to start this application, the privacy by design rule is also privacy by default. So all the settings in this app should be set automatically on the higher security level. So the person, for example, can say, okay, I want my photos to be visible to other people. Okay, but he had to do it manually, had to lower the security settings. This is also the rule. So by default, it's always set to a maximum, so a minimum data is used and is visible to other users. This is only an example of the privacy by design. This is the privacy by default part. So next thing is retention. Retention is also quite a challenge for our organization because the retention rule says we do not store data forever. So there is a time limit for us to store the data. There should be a day when we will say goodbye to those data and we will destroy or delete it. These obligations result from processing limitation rule and data minimization principle. So we have to check how long, for example, we legally have to store this data. Maybe we have some legal requirements in tax law, in labor law, but also we have to consider the business purposes. For example, we don't need legally this data, this list of some reports from clients or from employees, but we have some business purposes. We know that we will, for example, use it to estimate the future cooperation, but we have to consider it on the beginning. So, for example, we are signing the agreement with the client, and then in a privacy notice, in an information obligation, you can read, we will store your data for tax reasons, for legal reasons, for 6 years. But we have our own lists of potential clients because we estimate and evaluate the business cooperation. And that's why we will also keep this data 4 years longer, so in total for 10 years. So this is important, that we should have this horizons settled on the beginning. We cannot just collect the data and said, you know, we will collect them first, then we will figure out how long should we process. This is a wrong approach. And of course, we should securely delete this information. So we have to be sure that we actually delete this data from the whole organization. And of course, when I am talking about this, some of you will automatically think, well, this is problematic because we have emails, we have backups, we have security copies, we have pen drives. This is also something that we as an organization should manage. That's why we also train our employees. What you have to know and be aware of is that GDPRs allocate our business risks on a very low level of our organization. So when we have this fines, the breaches, many of them can be done by our employees, our managers, but our specialists, our consultants, because they will store some data that they should not, because they won't delete the data that they should delete, because they will collect the data without a legal basis. So GDPR allocates high risks and a low level of the organization. And here you can see the rise of the data subject. So we have the clients, we have our employees, and if we have to comply with GDPR in this area, for example, you have a company, let's say you will establish a company in European Union, in France or in Germany, then each and every person whose data we process have a lots of this rights. We put down 7, I think it's a full list. So each person have a right to access the data. He can ask us, dear company, what kind of data about me, what kind of information do you have? And also the right to access has a very strong addition, the right to have a copy. The right to have a copy, which once more can be quite a challenge. Let's say your employee or your clients asks you for a copy of his or her data. You have to go through the whole organization, through all of the processes, and be sure that you have identified all the information and that you copied and provided to the person requested it. So this is quite a problematic right. Then you have the right to rectification. Simply put it, the right to correct the data. So let's say my data is incorrect because, for example, I created an account in your online shop, and the data, my address data, my email is incorrect. I always have to have a right to ask you to correct it. And you have now you can see that in this particular moment that you have to take these rights into account when you prepare, for example, the project, when you design, privacy by design, once more, your application, because you have to be aware on the beginning, okay, we are creating this application, we are creating this company, we are creating this online shop. But we have to be aware that always a data subject may come to us with one of these requests. And are we able to copy all this information from the system? Are we able to correct the information? For example, one of our clients has a problem because the online shop is very old and it does not allow to correct some data, which of course is a mistake and it's breach of this privacy by design rule. So are we able to delete the data? We have always the right to delete the data. the right to be forgotten. Of course, this right is not, let's say, omnipotent. We always can say to the person, you know, it's very nice that you want us to delete your data, but we have a valid contract with you. We have a valid contract and we won't delete it. We cannot, for the second example, we cannot delete your data, our dear former employee, because we have a legal obligation to store this data resulting from a labor law. Number 4 is right to restrict processing, so freeze the data. One more challenge, are we able to freeze the data in our system? So there won't be modified, it will still be for a period needed by a person. Are we able to transfer the data, number 5, to another data controller? So for example, if we have some online app, if we have a, I don't know, Disney account, Netflix account, all these platforms have to, for example, on our request, transfer our profile from one country to another. This right was created by, was prepared by Commission because, as you may know, it's harder and harder, for example, to move from one service provider to another. Let's say you have an email on Gmail or another platform. It would be quite difficult for you to manually move page by page from Gmail to, for example, I don't know, Microsoft, mail by mail. And the European Commission said, okay, the service providers should make it easier for people, for clients, to change the provider, to change the company. And that's why we are all, if we have this online services, we are obliged to move the data. Of course, everyone can object the data processing. He can say, I don't agree with your operation. I do not agree with the processing, but we can, of course, refuse. We can say, we have a contract, we have a business target, we have a valid, legitimate interest to process the data further. And number 7, the person should not be subject to automated decision making, including profiling. So, for example, we should not hire people basing only on some automated processing, etc. This is a quite strong right, but of course there are exceptions to it. And it was created so that people would not be automatically evaluated, etc., without a human intervention. So, as you can see, 7 basic rights. Every person can ask us what kind of data we have and ask for a copy. He can ask us to correct the data, to delete it, but sometimes we'll say, no, we have a valid interest. Can say, okay, please freeze the data for a while. Can ask us to transfer the data to another service provider. He can say that he does not agree, but we can also deflect this, and he should not be subject to automated decision-making process. With exceptions, for example, in banking sectors, yes, it's obvious that the bank is automatically evaluating, preparing scoring, etc. And it's also normally put in a banking law in each and every country.
Michael, if you go to the next point, I want to come back for a moment for the previous 2 very important things, very important topics. I think about just really about saving money, because the data retention that we shouldn't store information without limits. That means that there are costs. If we have to do, because according to the GDPR, there are data retention. That means that we we don't have as much information as we need. That means we have too much, and that means we should check it and deal it, and we reduce cost and risk. Authorities is checking this every time. It's very, very important. It's very easy to check, because they see what we have and how long we store it. This is first. And second, your favorite, privacy by design. The goal is the same. It's not only not only things that we should do it, but it helps us to know what we have and to know what information, what we need, and to avoid fines. We will talk about fines and very high fines. And thanks to privacy by design, of course, it's not always is performed. This is the problem, because you said that it's your favorite, and we know that there is a problem that not everyone wants to do it, because it takes time a little, but it saves money, and that means limitation of risk. It's very important, because there are two ways to think about it. First, that we have to do it according to GDPR, and second, it's very useful for us as data owners, because we don't need this information. We should know about our processing and to analyze it before something happens.
Yeah, thank you, Thomas. True. And it's actually, privacy by design can be implemented in many ways. It could be a survey, so list of questions. It can be also a questionnaire in an IT system. It could be a meeting even with a DPO. You can make it in many different ways or forms. So we have to also secure the data. This is of course, key factor. So we have to take into account the state of art, what kind of technology we use, what are the risks, what are the costs of implementation, what is the nature, scope, context, and purposes of the processing, and what are the risks. So when we have all this together, we can implement the proper security measures. For example, some antiviruses, security copies, disks encryptions, etc. Sample measures are, you can see on the right, so pseudonymization and encryption of personal data to ensure the confidentiality, integrity, availability, and resilience of the systems. The ability to quickly restore the availability of the data. Also, regular testing, measuring, and evaluating the effectiveness of technological measures. And when we read it, we have to be aware that supervisory authorities actually check it. So, for example, they come to us with an audit. They ask us, okay, let's see your list of the processing. Oh, you have marketing, online marketing. You have the app. What kind of data you gather? How do you secure it? Do you really test and measure and evaluate your security systems? Give us proofs. Show us the tests. Show us audit results. And what if something goes wrong? What if something goes wrong? Then we have a completely new obligation, the data breach notification. So sometimes when we have a breach of security, this is the data breach of security, leading to some deletion, theft, alteration of the data, etc. So something's wrong with the data, something happens, and we have the risks for our clients, for our employees. We have 72 hours clockwise. It's not working hours. It's 72 hours, 3 days to notify the supervisory authority in that particular country. Sometimes, if the breach is international, maybe more than 1, 2, or even 3 supervisory authorities will have to be informed. This is something new, as you can see, and it's the origins of this is that European Commission thought that it would be a good idea for the supervisory authorities to be aware what's happening in a companies and in a public sector as well. So if something goes wrong, very often we have to notify the supervisory authority. And the worst case scenario is that we will fail to do it. Many supervisory authorities really don't like it, and they also can punish us up to 10 million euros or 2% of worldwide turnover if we fail to comply with this rule. And once more, it's a challenge, because we have to make sure our staff, our employees are aware if they send an email to a wrong address, if they delete the data of our clients, the data we need, if they made some information public, because, for example, the database was not secured enough and some hackers get access to it or stole it, etc. Then they have to come to us, not try to repair the situation themselves. They have to come to us, report this breach, and then the security officer, the IT team, the DPO will help to solve the problem, and they help to notify a data supervisory authority in that country. And believe me, we do it on daily basis. There is not a week, I will say it again, there is not a week that we do not fill this notification to a particular supervisory authorities, because people makes mistakes, and we know it, they know it, and also the supervisory authorities knows it. So worst case scenario is if the breach results from a system. So we have, for example, we didn't design properly a security measures. This is something problematic. But sending an email by an employee, this is his mistakes. Yeah, we have proper procedures. The employee was trained. He only made a mistakes. Okay, there were some risks to people, so we have to inform to the supervisory authorities. But what can this supervisory authority do? Not much, not much, because there is no system failure. It's only a failure of the human element. That's so. If we have a good system, if we notify, identify, etc., the notification of a breach is a normal part of the process. It will happen. And then if it happens, we have to stop and think for a while, why have it happened? And should we put some corrective and preventive measures, because this is something also the supervisory authorities likes to ask. So what have you done in this scenario so it won't happen again? So 72 hours, pretty strict. But putting frankly, in Chinese systems, like legal system, you have even more strict rule, because if you have this severe incidents that involve the data of 100 million Chinese citizens, according to Chinese law, you have to inform the public body in 10 minutes. So 10 minutes is also quite strictly. Here, 72 hours. So how to combine the GDPR with the business, how to implement this system in your organization. First of all, of course, you always have to have this personal data protection policy, this most general documents that tells why, for what, and how you process the data in your organization. Then you have to identify the processes. So what are the goals of the processing? We have, for example, marketing, sales, we have contractors, we have employees, we have video surveillance, etc. This is a record of the processing activities. Then we have information obligations and consents. So this privacy notice, we ask for a consent if we have some additional goals. We have to run this privacy by design and by default. So we have to have this privacy scan on the beginning and when we change the project. We have to manage the risk. This risk-based approach is also something that's quite challenging for the organization because we have to estimate the risk, but we have to switch the balance point from the risk to our organization to risk to the data subject. And of course, we have to have this procedure for selecting the contractor and data, we have to sign up the data processing agreement. And the responsibility of choosing the right partner also have the legal responsibility to only share the data with the proper trustworthy entity. Legal obligation to only share the data with a trustworthy party. That's why a lot of company are still coming to us because they wanted to make business. Yeah, they don't care about data protection, but their partners do. But supervisory office do. And that's why they get the surveys from their clients. Okay, we can buy your services, we can buy your goods, but if we have to share some data with you, we have to be sure you are a right partner, you are a secure contractor. That's why we will ask you, do you have personal data policy? Do you run privacy by design? Do you have right security measures, etc.? Also, retention of data. So we have to delete the data after some time. We have to implement the data subject rights, notify the data breach, and we have to be careful when we transfer data outside the European Union. This is very short overview. And also, we have to, as you can see here, how we can do it step by step, identify the processes, applicate the processing principles, identify the legal basis, prepare the documents and procedures, train staff, appoint a DPO and representative in the European Union, exercise the risk, prepare the risk assessments, documentation, evaluate the contractors, and run regular audits. So that's how it's done in a nutshell. And when we talk about marketing here, we also have to be very aware of the risk of purchasing the marketing databases. So it's always a good idea to build your own marketing database. In every place, in every website, when we have a contact with a client, with a potential client, with a person, this is an opportunity for us to ask for a consent, to sign for a newsletter, to give us a consent to send him or her some marketing mails or SMS. We are building our own marketing databases when we can. We obtain the consents. We have a newsletter. We can run the competitions, so also gather some data, give some rewards. We have to be very careful when we talk about profiling, and also when we hire marketing agents. They have their own risks, and we have to conclude a special DPA agreement with them. And Tomasz, you want to add something?
Yeah. Sorry, but this is my role to tell you that we have a shortage of time.
Yeah, this is the last slide.
Sorry.
Yeah, so you have to be aware that I'm speeding up. We have some legal responsibility. We remember that we have this administrative fines up to 20 million euros, 4% of annual worldwide turnover. We have a civil liability, so we can be sued before the civil court. This is something new. And in some countries, there are also some criminal liability. So we have 2 or 3 legal liabilities in countries. So supervisory authorities, civil courts, and sometimes criminal liability. And this is the last slide. As you can see, here we have the biggest fines. On the left, you have the winner, Meta, so Facebook, 1.2 billion euros from transferring illegally personal data of European citizens to United States. Then we have Amazon, almost 800 millions because of the advertising systems without a consent. We have a Meta once more Facebook. Child users, they didn't inform them enough. So this transparency rule was breached. We have the Meta once again forcing users to consent. They said, okay, you can give us a consent, but if you do not give it, you cannot use Facebook. So almost 400 millions. TikTok, handling of children's accounts. WhatsApp, 225 million euros, infringement of transparency once again, and Google in France, almost 100 millions. So as you can see, the fines are quite severe. Of course, the whole presentation will be sent to you on the end. Before I will give the voice back to Lucas and to Helen, I wanted only to briefly tell you that my name is Michael Czarnecki. As you can see on the beginning, I'm also attorney at law, doctor of law, and for a few years I had the pleasure to work for a supervisory authority, also in one of the European countries.
Okay.
Thank you very much, and back to you, Lucas and Helen.
Okay, thank you, Michael.
Thank you, Michael.
Right, Lucas, what do you think?
Yeah, it was an amazing presentation about the data protection regulation in European Union. I think it's very beneficial for the Chinese clients to know all the policies, liabilities they have to fulfill when go European market, right? In especially like providing the services and goods, as Michael said. So maybe you will, Helen, provide very shortly a brief like summary in Chinese for our Chinese participants about this very complex issue.
Okay, no problem. 感谢 Thomas、Michael 两位律师的详细讲解，我个人感到受益匪浅。虽然说，这些内容说起来简单，一共20页的 PPT， 但是内容都切中要害。首先，Michael 从 GDPR 的渊源开始讲起，那么它是否适用中国企业呢？以及个人数据匿名化这些概念，都给我们做了非常清楚的说明。另外呢，还有 DPO， 说到 DPO， 我个人有一个经历啊，就之前我第一次接触到 GDPR 的经历，就是我在游戏公司的时候，那个时候，有一款游戏他们要到欧洲去发行，那个时候我们也请了一些律师，还有这个咨询公司啊，去问什么是 DPO 啊，我们需不需要在发行游戏的时候有 DPO 啊？人家就跟我讲 DPO 就是客服。然后当时大家都是客服啊，信以为真。实际上，今天我们通过 Michael 的讲解，我们知道这个 DPO 的职责是非常重要的，它不是客服，它需要纵观整个数据合规的流程，然后还要监督公司的一些培训呀，做一些汇报，同时也是消费者的一个联系人。我们就是针对这个能够直接跟我们欧洲律师进行学习的机会，我个人是非常的珍惜的。咱们讲到了除了 DPO 的职责以外呢 ，Michael 还给我们聊了在业务方面的一些问题，比如说隐私的声明、隐私的设计，这都涉及到一些技术内容，还有一些数据的保留归档的一些原则和方法。数据所有方也就是我们普通民众的一些权利，在这个 信息保护上的技术措施，还有这个个人数据泄露的通知。关于这个个人数据的泄露通知啊，实际上在中国的个人信息保护法里面也是有的，而且内容的非常相近。实际上呢，中国的个人信息保护法也是参照着 GDPR 和这个 CCPA 的这些规定来起草的。特别是关于这个信息泄露的通知，还有这个 DPO 的一些规定。另外呢，那个 Michael 也跟我们介绍了非常严苛的法律责任，包括有1000万的欧元的罚款啊，就因为没有设置 DPO 就能产生1000万欧元的罚款，另外还有12亿欧元的这些罚款，我们听了就感到非常震惊。我没有想到，就是说欧洲市场对于数据保护是这么重视的。就经过我们今天的这一次的研讨会，我们都对 GDPR 还有欧洲市场，中国企业进入欧洲市场的风险有了更详细的认知。这都非常感谢 Thomas 和 Michael 的讲解。
Thank you, Helen, for this summary. One time, Tomasz, thank you very much for participating and being amazing lecture. Same for Michał. It was like very beneficial hearing all the inputs about the data protection regulation in European Union. As Tomasz said at the beginning of the webinar, we are only OM bridges, which means like we are sort of bridge between Polish, European, German, French, Spanish clients and the Chinese clients. We are not only lawyers, but we are also like the practical specialists. So we connect our client in order to make the business in more safely and practical way in between China and Europe. We invite all you guys to cooperate with us and make better the business between Europe and China. Soon we will launch our webpage, ombridges.com.cn, when we will put very interesting materials about GDPR law in China and in Europe. This will be beneficial for all you guys for making the business between all these regions. We also will be organizing the more specified webinars in the future for some sort of sectors. We will inform you on the webpage and also on our WeChat groups. After the webinars, we'll send you the materials, the PPT, which Michael and Tomasz prepared. And so thank you very much for today. Webinar. It was amazing having you all here.
Thank you all. 欢迎各位在3月27日周三下午4点到5点半参加的我们第2场研讨会。题目是在中国挣安心钱，中国数据安全法视野下的风险。有需要的朋友们可以在群里联系我获取研讨会的链接。好的，再次感谢各位，我们周三再见。
再见，谢谢。
Thank you very much. 再见。
Thank you all.